Good morning. I'm Guillaume Mortreux. I'm a trademark attorney at Ipside. Ipside is an IP firm that is present in France, in Paris, Bordeaux, Toulouse, Quimper, also in the US, in Las Vegas, and in China. The topic today is the new action in cancellation of a trademark that has not been seriously used for more than a 5-year period. It must be reminded that in France, the Trademark Office will never decide on its own will that a trademark should be cancelled because it has not been put to genuine use. Unlike what happens in some other countries, like in the US, for instance, the owner of a registration is never forced by the Trademark Office to show that his mark is genuinely used at regular periods, like every 3 years, for example. To get a registration cancelled because it's not seriously used, it is up to a third party to bring an action. It is now much more easier to obtain such a cancellation of a trademark that has not been used in France. Once registered, the mark constitutes a monopoly on a sign in association with products and services. This monopoly is an extraordinary privilege, which makes it possible to prohibit others from using an identical sign for protected goods or services. The other side of this monopoly is that a trademark must be subject to genuine use for all the goods and services for which it has been registered. In France, the holder of a registration enjoys a 5-year period during which the mark does not have to be used. However, once this 5-year period is over, in the absence of such serious use, the mark is weakened. It's weakened to such extent that it cannot be used as basis for an opposition, and it's also made weak because it can be subject to an action in cancellation. Such an action in cancellation is a very good thing because it cleans up the registers of those unused marks that, however, constitute a potential obstacle for new businesses. Unused registrations represent an unfair monopoly, which ossifies the economy since new businesses hesitate to launch their brand for fear of being, after a while, subject of an action in infringement. The action in cancellation for lack of serious use is the solution to get rid of this threat. However, before the implementation into French law in November 2019 of the EU regulations, such an action could only be brought before the French courts. The cost was often too high for a company starting its activity, which preferred then to change brand with the effect of maintaining the registers cluttered with dead wood. The new regulations of November 2019 allow the bringing of an action in cancellation of a registration, French registration or international registration designating France, directly before the Trademark Office, the French INPI, just like it has been possible for the EU registrations in front of the EU IPO for many years. It should be reminded, however, that the action in cancellation for lack of use is not the only case of action for revocation of a trademark, but it is the one we're going to focus on today. To get back to this action in cancellation for lack of use, it is a fast, simple, and effective action, but also very protective of the rights of the owner of the registration and of the one who brings the action. The action is simple. It's simple because there are no arguments to be given in support of the request, only that the mark does not appear to meet the requirements of use of the French IP code. It is requested to cancel it. The plaintiff does not need to justify any interest into his action. The plaintiff can initiate the action himself or through a trademark attorney or through a barrister. The action is also financially reasonable. The official fees to be paid to the Trademark Office are of 600 euros, and the fees from the attorney will be around 280 for the presentation of the action. Let's keep in mind, however, that it is advised that the action be preceded by an investigation in order to ensure that the mark has already not been used for at least 5 years. But this investigation is not mandatory, and in case the action in cancellation fails, there are no costs or damages to be awarded to the losing party. The action is also effective. Once the cancellation is pronounced by the office, the mark is simply removed from the register. The action is designed to protect the interest of the owner of the registration as well as the interest of the plaintiff or applicant to the action. It is divided into 3 phases. First, the pre-instruction conducted by the French Trademark Office, then the instruction, which is a real contradictory phase of the action, and then the rendering of the decision by the French Trademark Office. Each of these phases is protective of the interests of the plaintiff and of the defendant. These 3 phases begin with the enrollment of the cancellation request to the trademark register and end with the decision from the French Trademark Office. This request may relate to all the products and services of the mark or only to part of it. The pre-instruction. Once the request has been received by the French Trademark Office, it is immediately registered to the Trademark Bulletin in order to inform third parties of the existence of the action. The French Trademark Office will check on the admissibility of the request, identification of the brand, of the product and services concerned, payment of the taxes, identity of the requester, explanatory statement, although we've seen before, this statement is very, very thin. It is the French Trademark Office which carries out the investigation, which consists in getting hold of the owner of the mark so that it be informed of the action which threatens its right. It takes the form of sending letters to the various addresses that the French Trademark Office knows, or to the registered representative to the trademark. This pre-trial phase lasts for 2 months. It is followed by the instruction per se. The owner has 2 months to respond to the request. It is for the owner to show with supporting documents that there had been genuine use of the mark all through the 5-year period. The plaintiff of the action in cancellations enjoys 1 month to challenge the evidence of use, if any. The defendant has an additional month to answer and possibly to supply new elements. At this stage of the proceedings, the owner of the registration can request a hearing. The plaintiff enjoys then an additional month to provide new observations or new documents. And at this stage, the plaintiff can request hearings as well. The defendant enjoys one more month to submit new observations, but it is no longer possible at this stage to submit new elements of use. At this stage, the defendant as well as the applicant can request hearings before the French Trademark Office in order to present their point of view. The total duration of the instruction can be 6 months maximum if the parties have used all the faculties given to them to produce observations. It makes a total of 11 months, 2 months for the pre-instruction, 6 months for the instructions, and 3 months for the French Trademark Office to render its decision. This maximum length can be reduced to 7 months in case the owner of the prior registration does not answer, as it happens often. It is important to point out that the French Trademark Office will not notify its decision. It is important to point out that if the French Trademark Office does not notify its decision within the 3 months after the closing of the investigation, this closing being notified by law, it will mean that the request of cancellation has been rejected. If the French Trademark Office rules that the registration is cancelled, the cancellation will be enforceable at the date of the filing of the action of cancellation. However, Upon request of the plaintiff, the cancellation can also be enforced at the date on which the reasons for the cancellation first occurred. This could be important in the event of active infringements before the mark is cancelled, if the legal action is still possible. Therefore, the owner of the mark under attack may, before the end of the proceedings, renounce to the products and services attacked or to the whole registration. This closes the entire action. Or the defendant and the plaintiff can jointly request the suspension of the procedure for a 4 months period that can be renewed twice, which makes a total of 12 months period, during the investigation period or during the 3 months period left to the French trademark office to make its decisions. This could allow the parties to find ground of understanding in order to assign the trademark, for instance. The decision from the trademark office can, of course, be appealed before one of the 9 competent courts in trademark matters in France. As a conclusion, we can say that the new action is cancellation for lack of serious use of a trademark is a quick and easy way to clean up the register from unused trademarks. We, as trademark attorneys, we will push our clients to use that new action because it allows to wipe off the threat in case of an availability search that hits one or several problematic registrations that do not appear to be used. Prior to the action, it is necessary to conduct an investigation, but the investigation does not have to be long or expensive. It is a choice to make between the full investigation and the action in cancellation. Since there is no cost to be paid by the losing party, it is worth filing the action even with a light investigation regarding the use of the registration that represents an obstacle. The parties can of course also agree to organize the transfer of an unused registration. This allows the beneficiary to enjoy the seniority of the acquired registration, which then should be put to genuine use as soon as possible, since the change of owner does not cover the requirement of use. Our regulation encouraged such an approach of the holder of a mark by a potential buyer, since it provides that one can ask a trademark owner to provide evidence of use of his registration before filing the action. This amicable request to show the evidence of serious use of a registration opens a 3 months period during which the owner of the registration cannot make up fake evidence. He must furnish proofs that are dated before that 3 months period, starting from the original amicable request. But whether in demand or in defense, evidence of serious use of the registration is the only basis for the action and the only mean capable of ensuring the survival of the registration. This is why we're going to talk about now the way to present serious use in the context of the new action in cancellation before the French Trademark Office. When we are in defense, and when, unfortunately, this action takes us unprepared, it will be the race for collecting evidence. When we are the plaintiff and ask for the French Trademark Office to rule that the registration should be cancelled, it will be also for us necessary to conduct an investigation in order to make sure, or at least to be as sure as possible, that our action is going to be successful. Therefore, generally speaking, the evidence of use is the keystone of the action. It is then vital to provide for the safeguarding of the proof of use prior to any action and before the full expiration of the 5-year period. When we brought up the subject of the new action in cancellation before the French Trademark Office in the first part of this presentation, we placed instinctively ourselves from the point of view of the one who wants to have a registration cancelled. Now, when it comes to the subject of the proof of use allowing to defeat the action in cancellation, we will put ourselves on the side of those who want to defend their registration. This brings us to the second part of this presentation, the evidence of use in the context of a new action in cancellation for lack of genuine use. What are the type of use likely to undermine the action in cancellation? There is serious use or genuine use of a mark when it is used in accordance with its essential function, which is to guarantee the origin of the products or services for which it has been registered, for the purpose of creating or to maintain business for these products or services. And as stated by the Court of Justice of the European Union in the Minimax decision, serious use of a mark means an effective use of this mark on the market of the products and services for which it was registered, with the exclusion of mere token users having for only purpose the maintenance of the rights conferred by the registration or exclusively internal users. In the absence of evidence of use, there will be no alternative. The trademark registered for more than 5 years will be cancelled. To that extent, the French IP code is simple. Evidence of use lies in the owner of the mark, which cancellation is requested. It can be brought by any means. Yes, it can be brought by any means, but really with the respect of a certain form. The form for the presentation of the evidence are that they must be presented to the trademark office in a structured manner. It is essential that the evidence provided be numbered and reconciled in a list of exhibits, otherwise the proofs will be rejected. In my opinion, it is simply by reading the list of exhibits that the French trademark office will be convinced that the brand is or is not seriously used for the products and services at stake. A copy of the documents will be necessary, however, and will be used to strengthen the list of the exhibits. What are the prerequisites to the genuine use? Before we even discuss the quality of use itself, such use, if any, must be in a given territory, for a given period of time, and be authorized by the owner. The territory. We're talking about French registration and international registration that designate France. Therefore, it seems normal that it should include the use concerned the territory of France, as well as the overseas departments and territories. But also, the question is, what about exports? Affixing the mark on products only for export purposes without a real use in France will be considered to be serious use in France. What about the use of the brand on the internet? The mere accessibility of a website in France is not sufficient to prove use. There must be the possibility of deliveries in France. The site must preferably be in French and with reference to the general terms and conditions in accordance with French law. However, it has been seen that the sole accessibility of an English-speaking site in France with payment in USD can validate the use in France, but it must also be shown that there has been deliveries on the territory, and that there have been invoices and really act of purchase by French consumers. What is the period of time in consideration? We're talking about 5 consecutive years. The lack of use of the registration is not a normal situation, but its owner enjoy a sort of grace period of 5 years, during which its mark can be enforceable even if it has not been used. However, as soon as the 5-year period has elapsed, it is necessary to demonstrate use of the registration if we want it to survive. As an example, a mark has been registered on October 1st, 2015. It is necessary to show use of the mark as soon as October 2nd, 2020. With regard to registration that have been the subject of an exploitation, and then the exploitation stopped, the starting point to know if the action in cancellation is possible is computed from the last genuine act of use of the mark. Let's have an example again. A trademark is registered in 2000 and used until June 2015. We are in June 2020. We need to find out when exactly the mark stopped being used. If it is in June 2015, then the action is possible today. This rule seems simple, but in fact it can be very difficult to apply because very often the activity is declining for a long time. If the use is serious and continues for a certain number of years, the roaring period, we can say, then it ceases, for example, 5 years, then it starts again punctually, but in a way with quantities or even qualities that had nothing to do with what it was during the good times. We will therefore consider that there is no more serious use since the last act of marketing during the prosperous period. Any act of use commenced during the proceedings will not be taken into consideration. The 5-year period will not be suspended by an assignment. The fact that the mark has been the subject of a transfer when it was vulnerable to cancellation does not cure the admissibility of such an action. Neither does the renewal. The renewal does not cure the vulnerability of a registration. What about a new application? A new filing for an identical mark in order to start a new grace period will be considered to be fraudulent, and all the more so if the application has been made during the proceeding. An application for a mark in a different form, though, or for different goods and services, more precise goods and services, for example, will not be considered to be fraudulent. The new registration will not be vulnerable for the famous 5-year period. What about if use is resumed? In this case, the registration has been used, for example, for 10, 20, even 30 years, and then all of a sudden, after that very long period of time, use is resumed. We will consider that the registration will regain its solidity for all the periods, even when it wasn't used. To be taken in consideration, use must be authorized. The question is to know who is using the mark. It has to be the owner, or it has to be its licensees. But if the mark is used by an infringer, it will not be considered to be serious use. The question is also to know that the mark has to be used as a trademark, which function of indication of the origin of the goods or services. A company name, for instance, may not be considered to be sufficient to be used of a trademark, especially when it comes to product marks. It will be different for service mark like hotel or retail store. It's the company name, but it's also a trademark. We will consider that there is use of a trademark. What can be qualified as genuine use? It is said, and I've said it before, that the use of the mark must be public and non-equivocal. What does this precisely mean? It cannot be a token use, only meant to maintain the registration on the register. It's use on the marketplace as opposed to use only inside the company. Use must reflect the commercial being of the mark, that is to create and maintain a trading flows or products bearing the sign. Use relates to products that are marketed or whose marketing is imminent. The circumstances of the case will be taken in consideration in order to assess the importance of the transactions. The circumstance will be the nature of the good, the characteristics of the market. It will depend on the sort of products. Use does not have to be quantitatively important, providing it is constant and steady. Regularity and steadiness of the operation of marketing the mark is more important than mere value and turnover. Isolated, sporadic, symbolic, and facade acts will be refused. Frequency of use will be preferred over quantity. Frequency of use will be preferred over quantity. The importance is to maintain the commercial link and to preserve the market for the products. However, and I know it's kind of disappointing, the Court of Justice of the European Union has never set a real fixed threshold of quantities sold. Example, use will not be considered to be valid if it's only for 3 years and 3 invoices without other elements. Other elements are needed, like samples, orders, shipping orders. However, minimal use will be accepted if it's the result of a commercial failure. The best efforts of the owner will have to be shown. What about use only in advertisement? In France, unlike some other countries, advertisement is not enough to prove use. It has to be associated with other elements like invoices and orders. All the same, having a domain name is not enough, especially if the domain name is not used for the products. We're talking about use in a commercial way. What about use for free? The court always refers to commercial use, but the product given away will also be considered to be valid use, providing that it's given away in order to support another activity that itself is profitable. Examples, pens are given to support insurance or service companies. Non-profitable association give away T-shirt to promote charity and the collection of funds, the raising of funds, fundraising. What are the acceptable exceptions to genuine use? Because in some rare situations, even if there is no genuine use, the mark will not be vulnerable. Well, the first acceptable exception to genuine use is the famous 5-year grace period that I've already mentioned, starting from the day the registration is published and ending the following day after the 5th-year period. The 5-year period has elapsed. Preparation of commercialization will also be accepted if the preparation is imminent, if the marketing of the mark is about to happen. The advertising campaigns is already published. The goods have been delivered to the shops, but not sold yet. This will be considered to be preparation that are accepted by the French Trademark Office. There could be also good reasons for not using the trademarks. It's reasons beyond the control of the owner of the registration. Because of those reasons beyond his control, the use of the registration has been made impossible for a long period of time. The two requirements are that those reasons must be outside the realm of the owner and must be linked to the registration. For example, red tape obstacles makes the exploitation impossible or unreasonable. Pending litigation, financial troubles can also be a good excuse not to commercialize the marked product, but the financial troubles must happen after the mark has already been put to genuine use. The good reasons will always be examined case by case. It's a case by case appreciation. What about the use of the mark in a modified form? Use of the mark is in a modified form will be considered to be valid use, providing the modification does not alter its distinctive character. The distinctive character of the mark, the mark is still easily be recognizable. Recognition. There are two situations. Either there is only one registration or there are several registrations. If there is only one registration, the case is very simple. Someone files at a certain period of time and time flies and it is decided to slightly change the appearance of the mark. If the appearance of the mark is really the adjunction of a comma, of a question mark, or something like that, then it will something very, very light, then it would be considered to be a real use for the mark the way it was registered, although it's slightly different from the way it's being used. The question was raised for years about the situation when the owner of the trademark filed several applications, several marks. This will take us too far. So to cut a long story short, when the applicant files several marks together that are only different on small details, or when the applicant files one day a trademark and a few years after, because the mark has been slightly changed, files another mark, it is considered that the first mark, although not used, although used in a way different that has been also subject to registration, the first mark is considered to be seriously used. The question now, since we know what is serious use, where it should be applied, at what period of time, how, in what way do the evidence need to be presented? Because unfortunately, many times, how many times we hear the owner of a registration who is now subject of an action for revocation to swear, I may say so, that this mark is used, his mark is used, but he is not able to secure and gather all the elements allowing to demonstrate such use. The hard part for the owner of the registration is very often to dig into the material they have to be able to come to us with evidence acceptable by the trademark office. The evidence must all have a date or be datable. The evidence must show the place where the market products are used, and materials submitted without indication of date of use could be sometimes be relevant if it's possible to date them in one way or the other. And also, the evidence must be constant over the years. What are the type of material we need? In practice, the evidence can be invoices, but the invoices have to bear the mark, or to make us able to create a link between the invoice and the mark. Affidavit from staff can be acceptable. Catalogs, order, brochures, everything, as a matter of fact, can be acceptable, providing it's several evidence and not only one. Even if some relevant factors are missing from in some items of evidence, the combination of all these relevant factors and all the items of evidence may still indicate genuine use. As a conclusion of this presentation, we can say that only genuine use can put an end of the action in conciliation. A registration is generally used if it is used publicly and outwardly in the context of a commercial activity with a view to economic advantage for the purpose of answering an outlet for the goods and services that it represents. The evidence of such a use are numerous, but they all must be dated, and we can only encourage the owners of a trademark to use all the new system that there is and that allow systematic dating, like stamping device and software like this kind. This is now the end of this presentation. What we have to remember is that it is now much more easy to file an action in conciliation before the French Trademark Office. It is not costly, and the clients do not have to spend a huge amount of money in gathering or trying to find evidence for a trademark. It's better to let yourself go and file the action, and then we'll find out. there are no damages against the losing party. On the other side, if you're the owner of a trademark, it is important to secure the evidence day by day, because what is important is regularity more than having sudden pieces of evidence for a month and missing evidence for other years. I will be very happy to answer to your question when you make your when you present them online on our website. Thank you.